So a very brief introduction about myself. I'm Michele Collu. I'm the demand generation manager here at LawRoom, and I'm responsible for organizing these webinar events. Many of you would have received my invitation for this very event, so this is the chance for me to talk to you. Enough about me. I'd like to introduce our speaker today. It's Douglas Kelly. He's our head of editorial here at LawRoom and a California attorney with experience in litigating employment and labor law disputes both before state and federal courts. So following the recent amendment of the Fair Employment and Housing Act regulations here in California, we asked Douglas to put together this presentation. So today he will be walking us through the most significant aspects of the new rules and most importantly provide us with some practical takeaways that you will be able to relate to your business and kind of frame it in your own context. So thank you very much, Douglas, for presenting today. And I'd say without further ado, let's dive into the topic.
Great, thank you. Happy Tuesday, everybody. I am excited about this webinar. In half an hour, we're going to go over the new FEHA regulations and also provide you 7 practical takeaways that you can apply for your business as a result. So the Fair Employment and Housing Act, the FEHA regulations, became effective in April 1st, 2016. So many of you have likely implemented the necessary changes. But now what? This webinar goes deeper into these new regulations to create practical takeaways for you to handle harassment and discrimination in your workplace. Again, about me, that's my face. I'm a lawyer and a writer here at LawRoom. And my goal is to provide informative, topical content that educates employees about legal compliance and culture in the workplace. An outline of the course. So I'm going to do a brief review of the new regulations that created new obligations for you. And then we're going to emphasize the new regulations that clarified existing obligations. Now, these are laws that were already in existence even before April 1st. So let's start with the new obligations. One is the sexual harassment policy. So now you must include more information for your employees, such as how they can submit complaints and what to expect from you as far as investigating and resolving complaints that come up. You must also now distribute your sexual harassment policy in a way that employees will see it and acknowledge they read it. And there's 5 different ways to do this. And then finally, you must now translate your sexual harassment policy if 10% of your employees speak a language other than English. So you must translate it in that language other than English. And I also want to make a note that I put the citations for the specific regulation sections down below for your reference, so you can follow along. So we come to the first takeaway of the morning, and that's employees should complain. This will allow you to deal with an escalating issue faster. And this might seem counterintuitive, but if employees have more options or are more comfortable complaining, then you can get to an issue of possible sexual harassment before it harms anybody or it gets to a point of where it's illegal conduct. Another new requirement is training. So for employees with over 50 employees, you now have to keep records of the sexual harassment training you perform for a minimum of 2 years. And so you can see on the slide, the italicized portion is the new portion of the regulations. And so let's go through what type of record keeping you need to check. And so because many of you, even though these are new obligations that were effective April 1st, you may have not have conducted your sexual harassment training yet for your supervisor. So let's quickly go through these. You need to have records of the names of the supervisors you trained, the date of the training. This new regulation, again, it's in italics, is you must have a sign-in sheet or really some other kind of supervisor acknowledgement that they have taken the course. You also need a certificate of attendance or completion. You need to provide the type of training you provided. You need to keep a copy of written or recorded training materials, and you need the name of the training provider. And then content also, there are new requirements as far as what you must teach within the sexual harassment training. So there's 4 new ones. And the first is, you need to be able to educate your employees, your supervisors about potential liability and remedies available in court for victims in the workplace. Another one is that supervisors need to know they are obligated to report misconduct when they see it. Much more details about abusive conduct, so this is the bullying that happens in the workplace. And then finally, how to remedy harassing behavior, what you as a company are going to do to correct it. And these really fall in line with those new sexual harassment policy requirements we saw before. So takeaway number 2 from this is that provide comprehensive sexual harassment training. And by comprehensive, there's 2 things here. One is, there's a black letter law to teach, and that is necessary and required by the regulations. But truly, the second part of it is trying to educate your employees and provide them real ways to be compliant through harm reduction techniques or other ways that will allow your employees to stamp out bias before it happens or become more informed about things, sort of a ground-up approach in education. All right, so we completed the new obligations. Now let's go into clarifications of existing laws, and this is something I'm really excited about because we can really pull through interpretation of the comments made by the Fair Employment and Housing Council and the regulations themselves about, what this means for you. So the first topic is sex. So there are the new regulations codify definitions that were already established either through case law or legislative amendments throughout California and throughout time. And so one is gender expression. Sex includes gender expression. And gender expression is an outward behavior or appearance of a person's gender. And this is regardless of their assigned sex at birth. Gender identity is the internal identification as a male, female, transgender, or other gender that is, again, different from the sex assigned at birth. And finally, we have transgender defined as a general term that refers to a person whose gender identity differs from birth. And these are important because the regulations also tell us a little more about discrimination. The point of these is they want to put an end to anybody being treated differently, paid less, or treated adversely based on their sex. And so what this can manifest into in the workplace is, equal pay for substantially similar work. Persons of different genders or sex performing the same work, and if they're paid differently, that could be an issue, an example of discrimination. It also comes in the form of stereotyping a person's appearance, their behavior, or ability to perform work based on their sex. Sexual harassment is a type of sex discrimination. And then finally, and this is a really important point, is really any adverse action substantially motivated by an employee's sex is evidence of discrimination. And so what we did was we found comments to the initial draft of the regulations, and so we provided these as illustrations and further evidence of what these California regulators really wanted you as employers to know. So one commenter made the comment that many employers are unaware that discrimination on the basis of gender expression, again, this outward expression of your gender, is unlawful. The specific inclusions of these definitions may begin to change this common misconception. And the council response was no response required. And I think that brings us to our third takeaway, is that the definition of sex and discrimination, as we've seen, is very broad. And because it's so broad, employers need to focus on the ground up. And that's through education, that's through changing the language used in the workplace, and it's also people's attitudes or people's biases about sex that will affect employees. And so that's the third takeaway from this. Next, we have sexual harassment. There's clarifications. First is that sexual harassment does not require sexual interest. Second is that employees who only see sexual harassment can claim, hostile work environment. Another is that you don't have to lose a job benefit, like a promotion, to allege sexual harassment. And it's compared to discrimination where an adverse action needs to be shown. And then finally, a single act may be sufficiently severe to create a hostile work environment. In every case, is that true? No, but it is possible. We have input from the Fair Employment and Housing Council. So one commenter made the clarification that harassment must be both subjectively and objectively offensive rather than subjectively and objectively severe or pervasive. And so the council was like, they agreed, and they made this suggested revision. And so these are different elements of sexual harassment. And this brings us to our fourth takeaway, and that, sexual harassment. When we think about it, it hinges more on this concept of offensive, less on sexual, like somebody's sexual interest or conduct in regards to sex. And I think that's important to remember because, again, this is a broadening of this concept of sexual harassment. We want to avoid anybody feeling targeted or harassed based on their sex. That's the core of sexual harassment. And if they're going to find it, and other people will find it offensive as well. We also received clarifications on pregnancy leave. And so what was specified are three things that we took away from this. First is that pregnancy leave does not need to be taken in one continuous period. It doesn't need to be taken in a 4-month block. Second, employees are eligible for 4 months of disability leave per pregnancy, not per year. So this is to suggest that if there's multiple pregnancies in a year, employees would be able to take that additional leave. And then finally, the regulations wanted to clarify that transgender employees can be disabled by pregnancy or become pregnant and may need to take disability leave. So an example of this is someone who is assigned a female sex at birth but identifies as a male can still become pregnant. And so the regulations wanted to ensure that these people were still included, and employers included these within providing pregnancy leave. We have input from the Fair Employment and Housing Council. One commenter said that, the 4 months definition should be uniform for both continuous and intermittent leave, both to avoid confusion and ensure equity in leave entitlements. And so the council said, yes, we agree with your conclusion, and they reverted their original text back to its December 2012 form. So remember, back in December 2012, the pregnancy regulations were highly amended. And so let's get to the fifth takeaway of this webinar, is that 4 months is the law. It's helpful clarification for both employees and employers to remember how much leave someone is entitled to. But that's a general concept, because it must be carefully applied to the employee situation, and that comes in a few instances. One is that, again, this could be intermittent leave, that leave that doesn't happen in just one 4-month chunk. It can also apply if an employee continues to be disabled by their pregnancy and that they need additional leave. That is also a factor, and so there's no box to check with pregnancy leave, even though the 4 months is a very helpful guideline and necessary. National origin is another subject, and so the regulations clarify that employers cannot discriminate against non-citizen applicants or employees who present AB60 driver's licenses. Now, these are licenses that allow, for example, undocumented workers to be able to drive around to get to work and do the necessary things they need to do, like all Californians. So that's what we mean by an AB60 driver's license. And also, in discrimination, employers cannot require proof that an employee has a driver's license unless it's a neutrally applied policy throughout the workplace. So, for example, if you employ drivers and you need to ensure they have a driver's license, that's something that's applied equally throughout the workforce. Also, if state or federal law require you to verify driver's licenses, it's done in a uniform manner, right? Again, it's employers not having the ability to go in and decide for themselves and choose between candidates based on these distinctions, because that would be national origin discrimination, potentially. And so the council responded to a comment, and they said, they wanted to clarify by passing these regulations that an employer is not required to hire anyone. They're just required not to discriminate on certain bases, and they were talking about national origin in this respect. And so based on that, and based on also, recent legislative amendments that happened in California that really protect undocumented workers or any sort of non-citizens who live in California, is that, do not treat undocumented workers differently. They're a huge part of the California workforce, and immigration decisions are really up to the federal government. You as an employer, you have your obligation with filling out I-9 forms and submitting them, but that's really it. There's no sort of wiggle room or decision beyond that federal requirement of yourself. So treat everyone the same. Next, religion is another subject from which we received clarification from the FEHA regulations. First, they're defining religious creed. This is the core of someone's religious beliefs, and that includes all aspects of a religious belief, and that includes religious dress and grooming. Second, an employer cannot refuse to hire someone because they have a religious practice that requires an accommodation. Employers cannot segregate employees' religious practices away from customers or the public unless the employee asks for it. Again, because this is changing the privilege of an employee's employment based on religion, this protected classification based on their beliefs. And then finally, you can still potentially discriminate against a person's religious creed, regardless of whether you granted an accommodation. And so again, let's look at the council response to this topic. They said, and they wanted to clarify that the regulations cannot comprehensively enumerate every practice and circumstance that may or may not be a reasonable accommodation when it comes to, an employee's religious practice. Again, that's, very broad and inclusive definition of religious creed. And as far as how you as an employer handle that in providing an accommodation, there's no one concrete example. Because it's a similar concept, we're talking about accommodations. Let's also talk about disability. The FEHA regulations clarified these mandates. First is that an employee with a disability, much like religion, can still claim discrimination, even if they were granted an accommodation. Second is support animals. So these are animals that bring emotional support. Can be a reasonable accommodation, but the regulations are quick to clarify that it may not always be, right? Again, there's no one-size-fits-all when it comes to an accommodation. And we see that with the comments to the draft of the FEHA regulations, where one commenter said, a reasonable accommodation is subject to an individualized analysis, as are all accommodation requests. And the council agreed with this statement. And so this brings us to our seventh and final takeaway of the morning, and that's when on notice of an accommodation request, such as on a basis of someone's disability or religion, really dive into detail here. And there's a lot to consider as an employer. You need to dive into detail, but not encroach upon an employee's privacy rights and their medical or personal details. And so often people start with the job description as far as how they evaluate whether somebody can perform the essential functions of a job. But I want to stress that the law also makes clear that privileges of employment is another needs to be accommodated as well, may not show up in a job description. And so think about, anything that makes someone feel different on the basis of their religion or disability is something you need to investigate and ask questions about and perform an individualized inquiry with every employee. Again, there's no one-size-fits-all when it comes to accommodations. And then so, in evaluating all of these regulations, to me, and I interpret them as having one big message, and I think that big message is to create a compliance culture. And so let's unpack this a little bit. What we see through these regulations are employers have increased responsibilities and are required to go into much more detail in creating a sexual harassment policy or in providing an accommodation. And also the definitions we have, the legal definitions, have broadened and include more employees and applicants and individuals. So to tackle that, to handle that, creating a compliance culture, really educating your employees, your workforce from the ground up, not thinking of these regulations as a grand calculus, as a way to just follow the law. It's deeper than that. And that's what I take from these regulations. It really starts with your core culture. And so hopefully these takeaways, these 7 takeaways of this morning, will help you evaluate your culture and see if you can include compliance into your everyday life. So with that, I want to say thank you to everyone who signed in and listened to this webinar. I got to say, we at LawRoom, us attorneys, love unpacking the law, analyzing it, and providing really practical ways for you to engage your workforce and better your workplace. All right, and with that, I'm going to hand it off to Michele. Thank you again.
Thank you, Douglas. That was great. Really great presentation. I'm sure many of the attendees today will find these takeaways very useful and will be able to practically apply them to their business context. To our attendees, I want to say many of you have asked in the chat. We will be making the presentation that Douglas just gave available as a handout. We'll be doing that just now. And as usual, after the event, we'll be also mailing out a recording. There's a lot of you logged in today. I know some of you have asked questions, but unfortunately we had designed this to be a pretty short event, so we won't be able to go into that. But we'll be making note of those and maybe try to address them separately. Lastly, I'd just like to remind everyone that, as usual, the LawRoom training programs have been updated to reflect the new FEHA regulations that Douglas just discussed. So if you would like to receive a demo of our new courseware and of our online training platform, all you need to do is to type demo in the chat box, and so that would be enough for us to reach out to you. One of our training experts will reach out to you and show you around. Douglas, have we made the handout available?
Yes.
Okay, so the handout is now available.
It's being downloaded.
Okay, it's being uploaded just now, so it will be live up for you. And of course, as I said, if you typed in demo, we'll be reaching out. If on the other hand you prefer to reach out to LawRoom yourself, my contacts are now flashing on your screen, so you can shoot me an email or give me a call. I'll be happy to take your inquiries and talk to you a little bit more about LawRoom. I'd say with that, our broadcast ends up here today, and thank you everyone for being with us once again, and stay tuned for more of these events from LawRoom. We'll be doing more in the future. Thank you.